2. So I'd like to call the meeting to order. Can I have a roll call?
Sure. Member Basha?
Here.
Member Giotti here. Member Parka?
Here.
Member Tominello?
Here.
Member Bloom?
Present.
Chair Murray is excused.
And if I could get a motion for approval of the agenda? So moved. Or any discussion?
Support.
All in favor?
Aye.
Now we can look at the minutes of October 19th. If there's any discussion, any corrections, or if not, a motion to approve?
So moved.
Support.
Any discussion? Hearing none, all in favor, say aye.
Aye.
The minutes for the October 19th meeting is approved. That gets us to the hearings and reviews. Could I have the first case called, please?
Sure. It's case number 14-17-SC Sterling Land Ventures, Brigantine Water's Edge.
Okay, is the applicant here?
Good evening, Josiah. My name is Phil Adkisson. I'm an attorney representing the developer. If you'd like me to make a brief presentation, I will, and then turn it over to my client, who's here to answer some more detailed questions regarding the site plan itself. When we were here last, there were at least 4 questions that the Planning Commission had that they asked us to look into. I think the most important of those was the access rights that this developer has over Brigantine Estates for the development that's before you. Our office researched the master deed and the records of the county to ascertain that the requirements of the master deed for removal of the so-called undeveloped land occurred as was required. We wrote a detailed letter to your attorney, and I have, as I'm sure you have, received a copy of their letter which confirmed our findings, and that is that the property was properly withdrawn, stands independent, but as a matter of state law, retains access over the roads and access to the utilities. So I think we've satisfied that concern, at least as to our legal rights. There was discussion about the special assessment. I'm proud to say I probably have established more special assessments in the state of Michigan than any other attorney. I represented the township that had over 100 of them for road improvement, dust control, and any number of other things. I'm very familiar with Act 180 of 1954 and all the court cases relating to the establishment of a special assessment district and the proper parties to be included and assessed according to the benefit that they receive. At this point, I think the special assessment issue is not really an issue for this planning commission as it relates to its decision on the preliminary site plan. I understand why you're interested, and I'm going to address the points of interest. My client is not at all opposed to paying his fair share of any special assessment that may be established with regard to road improvement, if the property is in fact developed. I'll be frank with you, we're hopeful we'll be able to reach an accommodation with the Air Force and that the property will not be developed. But if it is not, if that's not something that's going to happen, there's an absolute intent to go ahead and develop it in accord with the site plan that you have. And if that occurs, we will participate as appropriate in any special assessment district or supplemental special assessment district, whether it occurs under Act 188 or whether it's a function of the internal master deed assessment process. We understand that if we benefit from the roads and burden the roads, that that's something that we ought to participate in. We're quite willing to do that. Now, I called an attorney, Wayne Wegner, to discuss that and other issues that the adjacent condominium might have. He was very cordial and talked to me, essentially indicating that his clients, while they do not object per se to the proposed development, they do object to any roads or utilities being used to service it during development, construction, or after. I understand that. I sought to have a meeting to discuss any other concerns or objections the condominium association might have. And his indication to me was that his clients didn't wish to further engage in the conversation on the subject except to make clear those 2 points. I wrote him a letter, an email rather, confirming our conversation and asking him to let me know if I misstated my understanding of our conversation. I did not get a reply. And I reiterated in that our willingness during the process, before the process is finished, and after it's complete, to work with his clients to do the right thing with regard to development. I'll give you a copy of that email if you want. Sorry, this is my only copy. This was a lot for all of you. But I've highlighted the portions that confirm what I just told you. And then finally, I know there was some discussion at the last meeting about whether or not there was a bankruptcy case that affected this property. And another attorney in my office, Linda Mayer, actually assisted Mr. Elko and his entity in the purchase of this property. And so I'm not intimately familiar with it, but it is my understanding that he can confirm that this was purchased not out of bankruptcy, but from the bank that was the mortgagee and had foreclosed on the mortgage, and it was a direct purchase. Obviously, before he acquired the property, he went through the title insurance and title inspection process to assure that what he'd be getting would be good title and able to develop it. I don't have proof of that with me tonight. I understand why you might be concerned about it. If it is something that you're inclined to pursue further between now and final site plan approval, and you want to condition your approval this evening on us satisfying your attorney that there is no bankruptcy issue associated with this property, we will do that. We'll do the same investigation as we did on the access issue, write a letter, and have them confirm it. But I'm confident that it is not an issue, and that there's time enough to find out if my statement is accurate. So with regard, those are the legal issues that were addressed at the last meeting, and Mr. Elko is here to address any other concern you might have about the detail of the site plan.
Okay, thank you.
I'm gonna flip this was our original color rendering, which is much,
Can you come up to the podium if you're gonna speak?
yeah. There were concerns from lots 25 through 29. They wanted some further information and detail on the site plan regarding those lots. The engineers have placed that information on there.
Okay, if I could stop you there, just so we know what we're looking at, because with respect to the site plan, we have, from what I understand, this started with a preliminary site plan dated August 3rd, then we had an enlarged resized plan dated August 31st, then a revised plan of October 2nd, which we had before us at the last meeting. And from what I understand, the current plan that's at issue tonight is the second revision dated 11/2.
That is correct.
Okay, so we're working off of the 11/2 second revision.
Correct.
Okay, you may proceed.
Yes. So the question was on lots 24, or actually 22 through 29, to make sure there was an adequate building envelope. We have put the typical building size on there of 40 by 40, which is actually larger than your ordinance requires. So these are, in fact, buildable lots.
So can you talk about, because we had questions on 19, 22, 25, 29.
Yep,
So you're
19 is
referring
also,
to all of those?
yes, 19, you'll see the 40 by 40 in the rear yard there.
Okay.
What was your other one, sir?
22, 25, and 29, I'm looking right now.
Yep, 22, 25 is 40 by 40, and 29 is a 30 by 50. So once again, that more than exceeds your minimum requirement.
Okay.
And on final site plan review, those building envelopes may get larger if we decide to mitigate some wetland and go for a larger building envelope. What this is for is just to say that this is a buildable lot. I believe if I were the residents, I'd have some legitimate concerns. We've worked with other properties before where we came in after a site was partially developed, okay? This isn't our first time of coming into a subdivision where we had existing homeowners and we purchased property from banks or other areas, okay? This is our fourth or fifth one we've done. So, we've already, I kinda have, there's 8 points if I was them, I'd have questions in regards to. I don't wanna put words in their mouth, I'm sure they'll have their own questions this evening. But, the first one is the SAD, and if we don't work a deal out with Selfridge, which we are, in the works of trying to do, one of the key points to that is we need a approved site plan in order to establish value. If the deal doesn't come through, we would sit down with the residents, go through the master deed and participate in, I believe, my opinion would be Cannon Drive, because that is the primary access point for this particular portion of the subdivision. We've addressed, we do believe we have legal access to the roads, as does your council. We would also work out a deal in an agreement with them in regards to, we have a very similar project at Crystal Wood that was also purchased from Sterling Bank, where there was a subdivision in back. We agreed to a split maintenance contract on the access roads we have. So our condo association would, you'd like me to stop, sir? Okay. Our condo association would participate in the snow plowing and maintenance of what I believe is fair as Cannon Drive. We would have construction signs up to bring in the construction traffic through Cannon Drive. We all know people are human. I can't guarantee that, everybody will use Cannon Drive, but that's our intention, is to have construction traffic travel Cannon Drive. The naming rights in a separate condo association, it's our belief, and I believe it's theirs also, that we would like 2 condo associations. Their subdivision is almost complete. Ours would be just beginning if we don't work out an agreement with Selfridge. So they would have their existing condo association, we would have our condo association. There would be a split maintenance agreement, Phil, is that correct? Where, and I'm okay just calling it Water's Edge instead of Brigantine Water's Edge. I think Water's Edge is a very nice name for it. Water's Edge would participate in plowing, maintaining the Cannon Drive area. And then, the quality of housing, we're planning on building, a good quality house in there. Also, if we look at we've reviewed the requirements from Selfridge, we're willing to participate and, build to their standard also.
Okay, thank you. Okay, before we get too much further, I think what I'd like to do is just review where we're at on this. And the reason I say that, we've had a lot of information presented, a lot of discussion that brings us here tonight, and I would like to just clarify where we're at and what the planning commission's being asked to do tonight. And we've already established that we're on the second revision to the site plan, so we're working off of that. We do have from the planner the October 12th, 2017 letter, which was the planner's discussion of the revised site plan. So I'd ask the planner if that's the latest, or if there's any comments. You had a couple of points on the second page of that. We now have a second revision. Is there any additional comments from the planner?
Excuse me, no. My letter from October 12th of 2017 still stands, and that's still my recommendation. I have, of course, a copy of the November 2nd version of the site plan. There have been no changes, only in addition of those building footprints to those particular lots, which do demonstrate that you can construct a house that meets the minimum dwelling unit size per the ordinance. So those are the addition of those footprints on the plans. Other than that, nothing else has changed. So my October 12th letter still stands, and I continue to recommend that the Planning Commission would move forward with preliminary site plan approval.
Okay, and specifically, you have a number 2 on the second page of your October 12th letter, and you're talking about Lot 19 specifically, and then you ended it by saying the Planning Commission should consider whether this lot should be eliminated. Is that statement no longer the planner's position?
I still am concerned about lot number 19, just because of the fact that they would have to put the house toward the rear of that lot as opposed to the front due to the presence of wetlands there. And I say that because you'd have the lot number 20, for example, that would have a house presumably at the front setback line, whereas lot number 19 would have a house in the rear setback line, just for consistency's sake. I think, I do believe that I agree that it is a buildable lot. You could put a house there. It does meet the minimum lot size and standards. I still think the Planning Commission does have the authority to say that we don't believe that that should be a lot in the plan set. But that would be up to the Planning Commission. I think it could even be something that's fleshed out more at the final site plan. As I said, it does show a lot that meets the standards, and you can build a home per that, where they show that 40 by 40 footprint.
Okay, so it's something for us to consider tonight?
Yes.
Okay, very well.
But that doesn't change my, I would still recommend that you move forward with approval of this preliminary plan.
Okay. Then I would also like to point out that we have 2 legal opinions from our attorneys that basically spell out things that we should be considering, things we should not be considering. And I just want to take this time to make sure that everybody understands where we're at and what we will be considering tonight and not considering. One is there's been some discussion about a memorandum that we received, or a letter that we received from Selfridge. And we have been advised that that is not legally binding, but it is an adjoining landowner. So it's for consideration as any adjoining landowners. So that is something for consideration, but not binding on the Planning Commission. The other things we talked about, the proposed SAD and the capping of the Brigantine Estates private roads, quite frankly, are not something that's at issue for us tonight, something that may or may not happen in the future, but it's not part of this review tonight. And then another thing, and we've heard discussion about it tonight as well, and we've heard about it before, is the negotiations between Selfridge and the applicant. That's also something that is not a factor in the decision to be made tonight. So those are things that have been presented but are not factors. The things that are factors and what we are reviewing this under are the planning standards, under the site plan review, and I would, for anybody that wants to look at it, is section 3.02. And it talks about the planning standards and what we should be reviewing. And it's vehicular access and circulation, relationship to the surrounding property, relationship to natural features, and infrastructure. So that's what we're focusing on tonight, on whether this will be approved or not. So for legal counsel or planner, anything additional or different than you would like to say than my summary?
Very well summarized, nothing to add, Mr. Chairman, thank you.
I would say the same for myself.
Okay. With that, any questions from the commissioners to the applicant?
I'll go ahead and make a motion to approve the preliminary site plan review, case 1417 SC, Brigantine Water's Edge, with the caveat on lot number 19, that either lot number 19 be removed from a residential building site or somehow mitigated so the house can be in alignment and harmony with the other surrounding residential properties when built.
Okay, we have a motion. Is there support?
Support.
And I think because we've had so much discussion on this, rather than a voice call, I think we'll call for a roll call.
So you want to take questions? Public comment?
Oh, public, sure, we can do that. Open it up to the public, for the public comment?
Yep.
Sure. If anybody would like to comment before we address the motion?
Good evening, Board. My name is Bill Servil. I'm here as a private citizen. I understand that the site, the master deed does spell out quite plainly that they should have access to the road. But I do have one question. Bankruptcy was mentioned, but I haven't heard anything about the terms of the bankruptcy. And we don't know what they were. They could have set aside the whole master deed for all we know. I don't know that that happened. But what comes to mind is when General Motors went bankrupt, they told General Motors they had to get rid of a nameplate, they had to close dealerships, they set all kinds of rules on them. So I don't know what could happen. The other issue is that Selfridge has three, I guess you'd call them crash zones. And the first one is called a clear zone, and it's 3,000 feet off the end of the runway, 1,500 feet either side of it. This whole site is in that clear zone. And what that clear zone spells out, according to the Air Force rules, is that there can be no structures in it. So I really don't understand why we're talking about this. I understand it. The Air Force's rules are not applicable here, they're not enforceable here, but we are the host community for Selfridge, and I don't want to see them go away because I'm afraid of what would happen to that runway if Selfridge pulled out of there. So anything that will make that more viable base is something that I'm in favor of. And I understand that this gentleman concurs with that idea. He doesn't really, his first choice is to sell the land to the base, but I don't understand why that can't be done without platting. I do have some stuff here that I put together that might be of interest to you. You don't need to look at it now, but hand it out.
William Bardell, clean cut boy next door, 21-year resident. I just want to ask the Plan Commission Board and our planner a couple quick questions. Did the applicant, number one, buy the property before it was declared a crash zone by Selfridge? That's my first question, and I think it's an important question. Did the applicant indeed buy the property before or after it was declared a crash zone by Selfridge International Base, Guard Base, Air Force Base? The second question I want to ask, and this may or may not be more important, to me, in my heart of hearts, think it is pretty important. Did the applicant reach out to the homeowners directly west of the project and engage with them, sit down, have some pie and coffee, and reach a conclusion, a workable conclusion about the road and about the details of the road, and put it in writing? And I think it's very important as a good neighbor policy that that was indeed done and in writing and hopefully notarized. So thanks a lot. That's my 2 cents. Thank you, Board.
Thank you.
Good evening, ladies and gentlemen. My name is Sandy Fullerton. I'm the president of the Homeowners Association of Brigantine Homes. Our attorney sent your commission a letter dated November 10th. I would assume you're in receipt of that. It was sent to Ms. Mancini.
Yeah, I do not believe that we've seen that and received that.
Interesting. Okay, that letter spelled out some issues that we have with this, and it's vis-à-vis the rights of access, the right-of-way that was approved, and the master deed initially approved by your board that went into bankruptcy. We don't feel that the current owner of that property is the legal successor. Our attorney has not researched that as of yet because we've asked him to hold off until the appropriate time. But with our experience with the bankruptcy that we were left with, when all the money that was supposed to be held in abeyance for additional lights, capping of the roads, and other issues, we were told that all that money went away. Now, this planning board is at the decision point of granting access through our private roads to a landlocked piece of property, which we understand. But I've heard no conversation of any agreement that the township would hold this developer liable for any damage to our thoroughfares, any agreement. Now, he has personally reached out to us and asked if he could do things like he has just suggested before this board. However, we feel that it would not be appropriate until this board decides whether he's going to go ahead or not. At that time, we would then engage him into the maintenance and repair of the road. Further, we've also heard no explanation of how he would be advertising this, what the signage would look like at the entranceways of his subdivision, and the naming where we have a beautiful entranceway to both West Offshore and Cannon Road, and he would then be building, I'm sure, something similar, or perhaps not. We have no idea what he's planning to do. Further, your board and the township required that we put in our own private storm water system with upstream defenders. Now, I understand he has a legal right to tap into the city water and sewer system, but the stormwater runoff is ours, and I've heard no discussion about what he's going to have to do with the stormwater runoff. We privately maintain our stormwater runoff and the upstream defenders, and there's no arrangements to that side. Further, adjacent to the back of Cannon Road, there is a berm being built, and there's no understanding or discussion before this board whether he will maintain that berm that separates the two properties, or whether he is then going to change the elevation of the land at the property behind those homes that are on Cannon Drive, which I understand you're not supposed to be changing the elevation of the property. And so is his plan to leave the berm there or remove it? So there's a lot of questions that we don't have answers to. He's also going to put two homes on Cannon Road per his site plan. And my question is, how does he intend then to evacuate any of the groundwater that would come in through his sump pumps, and where is he going to evacuate that to the wetlands, I would suppose? Or is he hoping to tie into our stormwater system? So there's a lot of questions that have not been answered. Now let's talk about the road. He's talked about coming into an agreement to perhaps with the SAD and pay his fair share. But that would be for capping the roads. Where is the township and this planning board to give us a concrete answer to the question is what happens 20 years down the road when that has to be maintained? What happens with the cleaning and the sweeping of Cannon Road? Is his association going to be legally bound to help maintain that roadway? There's no discussion to that fact. And so while you're on the verge of making a decision, there's a lot of questions that have yet to be answered. And your attorney has stated that he feels that this applicant is the successor. I have no paperwork. My attorney has no paperwork, and I haven't seen any paperwork presented at this board other than opinions from the applicant's attorney and a brief verbal agreement from the township attorney. So those are some of the questions and conditions that we have, sir.
Okay, thank you.
Any questions?
Any questions from the commissioners? Okay, thank you.
Thank you.
I wasn't going to speak, but I'm going to speak. If,
Name,
all-
please?
Darren York, 3964 North Point Parkway. All you need to do is go to the deed, and this question about the easement and payment and all that is right in the deed. It says developer, this is B, section 1, roadway easements. Developer reserves the right, or reserves for the benefit of itself, its successors, and assigns an easement for the unrestricted use of all roads and walkways in the project for the purpose of ingress and egress to and from all or any portion of the parcel described above, captioned expansion, convertible, contraction, yada, yada. They did a contraction. All expenses of maintenance, repair, replacement, and resurfacing of any road referred to in this article shall be shared by this project and any developed portions of the contiguous land described above in the article's caption, expansion, whatever. Whose closest means of access to a public road is over such a road or roads. The co-owners of this project shall be responsible from time to time for payment of a proportionate share of said expenses, where shares shall be determined by multiplying such expenses times the fraction, the numerator of which is the number of units in this project, and the denominator which is comprised of the number of such units, plus all other units in the adjoining land described above. There it is. Read it. Tell us what you need to do.
Before you come up, anybody else from the public would like to address this issue? Okay, any responses?
Just briefly. Regarding Selfridge, both the United States Constitution and the Michigan Constitution prohibit the government from taking property without just compensation. Otherwise, if they decided they wanted your home or your subdivision, they'd simply declare it a clear zone, come in and ask you to move, not pay a penny. That's why the Air Force is anxious to negotiate with us and anyone else that falls within the limits of what they believe ought to be clear. They recognize that they have that obligation. There's an entire statutory and regulatory scheme set up to address that, to make sure that the provisions of the state and federal constitution are not violated with regard to compensation. And that's the process that is now underway. And I believe that they would like to see a preliminary site plan approved. I'm not saying they support this particular plan or any plan, but at least it would give the appraiser, who's an integral part of that process, some basis to begin to determine what the appropriate compensation is. They do not get to simply walk in and designate areas adjacent to their base as areas that they do not want developed without paying for it. And I think the attitude of those who think they ought to would be different if it was their property that was being designated. I keep hearing about bankruptcy. this property was acquired from the bank on a mortgage foreclosure. It was not a part of a bankruptcy. We're willing to prove that to you folks. We're willing to suggest that you make your motion, if you believe it's appropriate, contingent upon that. We have a lot of time between now and final site plan approval to make sure that that is the case. If we can't establish it, then, you know, we've got nothing. The question was, did we buy it before it was designated a clear zone? And I think the answer to that is we bought it after. It was there's a study, and I have it here with me, but I'm pretty sure that it occurred before this property went into mortgage foreclosure. But for the reasons that I indicated earlier, I think that's irrelevant. The gentleman who spoke on behalf of the homeowners association, I have not seen the lawyer's letter. You know, that's a problem when you call somebody and ask them, and tell them, we want to talk with you, we want to address the concerns you have. Ask them to work with you to try to be able to come here and present solutions to the problems that they might have, and they elect only to say that we don't want you accessing our utilities, we don't want you accessing our roads, and beyond that, we don't want to talk. I don't know what else we could do. But having said that, I still stand by what I said in my email to Mr. Wagner and what we've said to you earlier. We're going to work with these folks to pay our fair share if the property in fact is developed. Now, if it isn't, all the issues that are raised will go away. Stormwater, berm maintenance, sump pump discharge, long-term maintenance agreement, I think these are things that get addressed during the final plat and engineering associated with and all the rest. Your engineers, your attorney will have to be satisfied that whatever we do is within our rights to do, whether it's to discharge into the easements that we believe we benefit from when the property was withdrawn pursuant to the terms of the master deed or not. The last gentleman to spoke, I'm not sure what provision he's talking about, but I did hear him use the magical word units. Units is a term of art. It's a defined term in a master deed. It refers to condominium units. So what I suspect he was reading was language that was in the original master deed that is irrelevant as it relates to the property because it was withdrawn from the original master deed. When it was withdrawn pursuant to state statute, it still retained the right to use the roads and utilities and whatever, but it didn't remain obligated to pay all of the expenses of the adjacent condominium. Notwithstanding that, I recognize that it's appropriate, would be appropriate under Act 188 of 1954, that if we are burdening their property, that we pay an appropriate portion of the maintenance. And we're willing to sit down with them and talk about long-term maintenance issues as this whole process goes forward. We don't want to begin a relationship with the homeowners association on the new development that's not one that's collegial and mutually satisfactory to both parties. A lot of time to work out these details. I understand why they're concerned about them and why they would raise those concerns here, but this is a long process, and as you folks appreciate, we're at the very first step. A lot of opportunities to address those, and we commit to addressing them.
Thank you.
I'd like to make one more further clarification. The property is not in the clear zone. It is an APZ 1. There's a huge difference between APZ 1 and clear zone. The reason why I know this for sure is that in their original purchase of Mott's and Brigantine, they purchased this section right here from Brigantine Estates. Purchased it. Or actually didn't purchase it, they purchased an easement over it. That is in the crash zone, okay? This is in the clear zone just as the Brigantine Estates is in the clear zone also. Excuse me. This is in APZ 1, which is not the clear zone. Clear zone, I agree with this gentleman's assertion that the recommendation is nothing be built in the clear zone. APZ 1 is what Brigantine Estates is in. It's what a large number of homes in your community are still in.
So just for clarification on that, I'm looking at the Michigan Air National Guard letter of September 20th. And the statement in here is that the Brigantine Water's Edge parcel borders government-owned property acquired in the 80s, and it says, and lies entirely within the Accidental Potential Zone 1, APZ 1, and is incompatible with airfield operations.
Correct.
Now, let's divide that into two portions. The first part of that, APZ 1, you agree with?
I agree with APZ one.
Okay.
The clear zone, which the gentleman referred to, is the portion of property in Brigantine Estates, the first Brigantine Estates that they purchased the easement over, and that's why there's no houses on the lots adjacent to mine going out Cannon Drive.
Okay. Any questions from the commissioners?
I have a question for council, for Mr. Booth. In regards to the gentleman from Brigantine Estates, his concerns that he had brought up, is there anything that he had mentioned that we as a board should be concerned about in terms of making our final decision?
No, there are issues that he raised that, that I can see need to be resolved down the road, but not tonight. And many of them will be resolved between the two parties here. Their attorney, Mr. Wagner, I've worked with him over the years in getting through those things, and I'm confident he understands it, and the sides will get together. But in terms of what you're viewing tonight as issues, I don't see any.
Okay, thank you.
I think we just need to keep in mind, this is a preliminary site plan review, so this is more like a concept. And as Mr. Hu said, and Mr. Wagner, you know, a lot of these issues relative to sewer, stormwater, everything else will have to be worked out. And I think we're very diligent when it comes down to the final site plan review on how we review those and make sure that we make sure the applicant and the developers adhere to our standards.
Okay, anything else?
The only thing I'd like to do is, if I can, I have a motion, and I would be willing to add to the motion that the property in question, that the applicant must establish that the property in question was not a part of bankruptcy, provide proof of that to the township, township planner, township, and township attorney, as part of the approval of the preliminary site plan.
I'll amend my support accordingly.
And I would think, and maybe I can refer to legal counsel, but it would seem to me that if there's not legal title to the property, then this doesn't go through, but I think that's appropriate for the motion, but I think that would be by operational law as well, would it not?
It would be by operational law, but you know what, council has suggested that they're gonna put the issue to rest and work with us on it, so why not put it to rest? So I agree with the
Very
addendum.
Okay, so we have an amended motion. We have the support to the amended motion, correct? Anything else before we ask for a roll call? Okay, if we could have the roll call?
Yes. Member Tominello?
Yes.
Member Boccia?
Yes.
Member Parka?
Yes.
Member Luljati, yes. Member Blum?
Yes. Okay, we can move on. The next item on the agenda is the public hearing. You can call that?
Sure. Next item on the agenda is public hearing.
Okay, if you could take that out in the hallway, please.
Next item is public hearing, zoning ordinance and zoning map amendments in a DDA district.
Okay, and maybe I'll ask the planner to address this.
Planning commissioners, and for those in the audience who are still sticking around here, there is a public hearing this evening on proposed zoning ordinance amendments related to the Harrison Township Downtown Development District. I just prepared, kind of just wanted to talk about why these amendments have been prepared and why they're in front of you this evening, and what, generally speaking, is included in the amendments. Tonight is a public hearing. It was legally noticed 15 days in advance of this meeting, published in the newspaper. A copy of the draft amendments have been available at Township Hall over that time period as well for public inspection. This is stemming, these proposed zoning ordinance amendments is stemming from the originally prepared waterfront redevelopment plan. That was done, I believe, in 2013. It was prepared by the township, and it resulted in a number of things. First of all, one of the implementation recommendations from that plan was to establish a downtown development authority. That did occur. Another recommendation in that plan was to prepare zoning amendments related to the waterfront district that are customized for the downtown development district, that would encourage and try and entice good development within the district. And stemming from that, following that recommendation, after the DDA has been working on it for some time, they now have in front of you, the Planning Commission, these draft amendments. And again, seeking to prepare customized regulations, zoning regulations that are applicable to the Downtown Development Authority District, to encourage and allow for a mixed-use, pedestrian-oriented waterfront district developed around a unique and unified nautical theme, and also to encourage and allow for sustainable development within the district. Included in the packet is a map that shows the specific properties that would be included as part of this new V1A waterfront zoning district. It doesn't include all of the properties within the Downtown Development Authority, but it does include most of the properties along Jefferson Avenue and Crocker Boulevard, fronting Jefferson Avenue and Crocker Boulevard within the waterfront district. Again, there is a map that that's part of this amendment as well. The new V1A waterfront zoning district, it has a listing of permitted uses that would be allowed in the district and special land uses that would be allowed in the district. It outlines various development regulations for the district. For example, setbacks from the road, building heights, orientation and layout of any new development. It also includes architectural design standards within the district. It includes special parking provisions within the district that, in fact, include an option to reduce the total parking. That was done from the DDA as an incentive to bring in more development, allow for more development within the district. It also allows for pervious surfacing as an allowable parking surface after, and of course, following certain standards. And then the district also includes stormwater management standards, ensuring and encouraging and allowing for best management practices as it relates to stormwater, allowing for development in the waterfront district, for example, to have rain gardens and have that as part of a stormwater plan for retaining water on those sites. So that is a summary of the amendments. As I said, the details, of course, are in the document that you have in front of you as well. I'd be glad to answer any questions that you might have of me this evening, or after the public hearing is held, if there are any follow-up questions that I can try and help out with, I'd be glad to do that. And just to let you know that the Planning Commission is a recommending body in terms of any zoning amendments. And so these amendments would ultimately, after the public hearing, if you wanted to move forward with the amendments this evening, it would be forwarding a recommendation of adoption to the township board for their later approval. Thank you.
Okay, I think first, I will see if the commissioners have any questions for the planner before we ask for comment from the public. Hearing none. Now, this is noticed as a public hearing, so we do not need a motion to open a public hearing, correct?
I think we still have to open it.
Do we?
Yep, because we have
Okay,
to have
is
a
there a
roll call.
motion to open the public hearing?
I'll make that motion.
Support.
All in favor, say aye.
Aye.
It's a roll call?
You need a roll call on the
Yep.
public hearing? Okay, can I have a roll call?
Member Tominello?
Yes.
Member Ojeda, yes. Member Baccia?
Yes.
Member Parka?
Yes.
Member Blum?
Yes.
William Bardell, 21-year resident. I'm a journeyman steam fitter. I'm not a lawyer, but I just want to remind our planning commission and our planner that the planning commission is the ruling body. You can, or you may or may not take the recommendation from the planner. I just want to make that clear, and, you know, for whatever reason, whatever your thoughts are, I just want to put it out there and tell you that this planning commission makes the decision. The planner can recommend to the board, but you guys make the decision. Just putting it out there, just letting everybody know that that's how it works. Then, of course, you guys will put your motion to the township board. So, just want to remind everybody that's how it works. Like I said, I'm in a different trade, but I do know a little something. So, our planner can make a recommendation, but you guys make the decision, and I appreciate your work. Thank you.
Any other public comments? Hearing none. Anything else from the commissioners?
Make a motion to close the public hearing?
Support that.
Okay, we have a motion to close and support. Can we have a roll call on that?
Sure. Member Tominello?
Yes.
Member Parka?
Yes.
Member Ojeda, yes. Member Baccia?
Yes.
Member Blum?
Yes. Okay, so the public hearing is now closed. We have before us the zoning ordinance, and this is, as we have heard, a recommending body. So is there any further discussion or any motions on recommendations to be made with respect to this proposed zoning ordinance?
I've got a question either to Adam or Mr. Huth. The document we have in front of us is a 21-page document. There's no date to it or any way of referencing what this document is other than a document in front of us. Is that necessary relative to any form of a motion that we make reference to something?
Just so I understand, Mr. Baccia, how did you guys, did this come in your packet for backup materials, the ordinance that you're talking?
Yes.
Okay. So that may, one way to do it be reference a motion based on the materials provided in preparation for the meeting tonight, as has been discussed by the planner, if you want to identify it that way.
Fair. I was just looking to have something to tie it to what we're approving,
That makes sense.
or making a motion to, or whatever. I'll make, I guess that being said, I'll make a motion to recommend to the Township Board to approve the reference zoning ordinance amendments to the DDA district as provided in our board packet for the November 16th Planning Commission meeting.
Support?
Okay, maybe some discussion. We have a motion and support. On the discussion and follow-up to Member Batch's comments, I do notice that page 21 is a certification page. It's a certification included on page 21, and it talks about introduction date, first publication date, adoption date, et cetera. Are those dates that should be included, are those dates that have already occurred, or are those dates that will be forthcoming?
That will be forthcoming if the township board would adopt this ordinance.
Okay.
They would fill in the ordinance number and fill out the certifications.
Okay, so those are all dates to be in the future. All right.
At the board level, we need to go through 2 public hearings. That's why you see first publication date, second publication date. So we'll go through 2 reiterations of what we sort of went through here tonight before it's effective.
Very good. Just wanted to make sure the document is complete. Okay, any other questions, comments, discussion? Okay, we have a motion, we have it supported. We don't need a roll call for this one, do we?
You know, because I think it's because it's a recommendation, I think we do have to do a roll call.
We should, okay,
Yes.
if you're, I don't know if you need to, but anybody
Yeah,
can
I
call
think
for
you
a
do
roll
on a
call.
recommendation to the board,
Okay, very good, I'll take that. as
because
a,
they'd want to know how many yeas and nays if we have to, you know, maybe weigh pros and cons.
Very good. So we have a request for a roll call. Could I have a roll call?
Member Tomanello?
Yes.
Member Baccia?
Yes.
Member Lijadi, yes. Member Parka?
Yes.
Member Blum?
Yes. Okay, passes. Okay, unfinished business, there's none. New business, at least per the agenda, there is none, unless there's anything to be added at this time. Correspondence, we have none. Are there any additional comments from the planner?
I'd like to invite the planning commission to the next DDA meeting, which is on November 28th at 7 o'clock. The DDA is continuing their discussion on complete streets. They're working on the preparation of a complete streets plan. So if you're interested in attending, it would be November 28th.
All right, thank you.
Thank you.
Any comments from the floor? Hearing none, the next planning commission meeting will be December 21st. If I could have a motion to adjourn?
So moved.
All in favor?
Aye.
And thank you for attending.